I'm Kalyan Dutt, faculty for Indian Constitution, for the students who are preparing for civil service examination. Don't want to drag too much. I will stick to the one point only. Ma'am told to us, ఏదో డెమో లాగా కాకుండా ఏదో టాపిక్ కూడా చెప్పండి అని చెప్పారు. సో రీసెంట్గా జరుగుతున్న వన్ ఆన్గోయింగ్ డిబేట్ని కాన్స్టిట్యూషన్ పాయింట్ ఆఫ్ లో మాట్లాడదామని బ్రీఫ్ 15 to 10 minutes లో మ్యాక్సిమం ఫినిష్ చేస్తాను. The debate is regarding marriage rights. Marriage rights. And అందరికీ తెలిసే ఉంటుంది, మన సమంత గారి సినిమా ఒకటి వచ్చింది కదా, సినిమాలో మ్యారేజ్ చేసుకుంటాను అని చేసేసుకుని తర్వాత మర్చిపోతారు కదా. ఐ గెస్ ఆంగ్లో సాక్సాన్ పీరియడ్లో కూడా ఇలాంటివి ఉంటూ ఉండేవి అనుకుంటా. సో దే స్టార్టెడ్ టు క్రియేట్ మ్యారేజ్ లాస్. అఫ్ కోర్స్ ఇండియన్ ఏన్షియంట్ పొలిటికల్ థాట్లో కూడా, ధార్మిక్ లాస్లో కూడా దే హ్యావ్ మ్యారేజ్ లాస్ వెరీ స్పెసిఫికల్లీ. Well, straight to the point, when marriage laws are framed, but before going to that, sociologists believe marriage is one fundamental institution, they will call social institution, common in all the societies. Interesting to note. Take, let us say, African societies, take, let us say, Asian societies, or go to any oceanic societies, you will find one marriage system. Well, this marriage system doesn't mean universal in all the aspects. There was some period one man can marry 2 wives. There was some period one woman can have 5 husbands. According to period and time and the circumstances, it started to change. Now, every society have their own structure of marriage laws. Well, it was in one of his speeches, it was written in the Panchajanya RSS journal also. He stated, that is Mohan Bhagwat sir stated, there is some kind of homosexual relation in ancient period. This was debated like anything. He is a conservative member speaking about same-sex marriages. This was debated, and one professor, Jawaharlal from Sanskrit universities, he stated he is correct. The evidence is the so-called Jarasandh samayamlo, okay, iddరు journals, డింబక అండ్ హంస, వీళ్ళిద్దరి రిలేషన్ని ప్రేమిక అనే పదాలతో జస్టిఫై చేయడం జరిగింది. అపార్ట్ ఫ్రమ్ దట్, వెరీ ఇంట్రెస్టింగ్ టు నోట్, సలీం కిద్వాయ్ అనే ఒక ఆథర్ రాసిన సేమ్ సెక్స్ మ్యారేజ్ ఇన్ ఇండియా అనే పుస్తకంలో కూడా హీ డిసైడెడ్ టు సే దేర్ ఆర్ హోమోసెక్సువల్ రిలేషన్స్ ఎగ్జిస్టెడ్ ఇన్ ప్రీవియస్ పీరియడ్. వెల్, దే హ్యావ్ లైఫ్. వీ యాక్సెప్టెడ్ ట్రాన్స్జెండర్స్. ఇన్ ఫ్యాక్ట్, ద ఎంటైర్ మహాభారత్ turned into the next level because of one security. We accepted that. But our society started to witness the colonial lens from the so-called 18th century. After this 1773 Regulation Act and so on and so forth. Ikkada manam chuskovalsindi entante, they started to judge us from the European lens. And there, when their European regions, particularly in UK, they rejected homosexuality as per their religious aspects, and it forced even think about Indian structures. From then, IPC 377 was introduced very interestingly. There is a person, European scholar, wrote a book, Ancient Law. In that book he stated everything which is against to our system considerably barbarian practices. So they started to justify something from their lens. You see, there is no time similarities between Kalidas and Shakespeare. But they can say Kalidas is Indian Shakespeare. No time difference between Napoleon and Samudragupta. They started to say he is Indian Napoleon. They started to judge from their lens. So 377 was introduced to the system. 377 bach gaya. Even Constitution enforced. The mighty Constitution, with its enforcement, brought political equality and it asked people to bring social equality. The political equality will come from 14, and it started to discriminate from 15, prohibition of discrimination based on gender. Not gender, that is what sex they used. So, this 377 still existed. One NGO is there. That NGO, we call it as a NAS Foundation. It works for the welfare of the gays and the so-called HIV patients. This NAS Foundation went to High Court of Delhi. There are some famous judgments of High Courts. Recently also we have one Haryana and Punjab High Court gave IMT Industrial Association versus State of Haryana regarding local reservations. One judgment recently struck down local reservation concept of Haryana government. మనం తెలుసుకోవాల్సింది ఏంటంటే మ్యాథ్స్ ఫౌండేషన్ దగ్గర ఏం జరిగింది. The judges clearly stated 377 is completely violating 14 and 15 and it should be declared as null and void and unconstitutional. And you have doctrine of eclipse. In fact, they won't struck down entire act. They try to some parts. So they removed this. Interestingly, this 2009 judgment again came to the Supreme Court in 2013. And this time, Supreme Court interestingly reversed the judgment of NAS Foundation. NAS Foundation said, అది కాన్స్టిట్యూషన్కి సంబంధించిన కాన్స్టిట్యూషన్తో పాటుగా లేదు కాబట్టి అది ఉండకూడదు అని చెప్పిన విషయాన్ని సురేష్ కుమార్ కౌశల్ కేసులో సుప్రీంకోర్టు మార్చేసింది. ఇట్ స్టేట్ నో 377 should be there. The court interestingly acted, in my opinion, against the Article 14. This was very much challenging to the many constitutional experts and number of people wrote several articles about Supreme Court opinion. Well, in this period, ఇక్కడ మనకు గ్యాప్ తీసుకోవాలి. బికాస్ మళ్ళీ ఈ కేసు పై జడ్జిమెంట్ అనేది డైరెక్ట్గా రాలేదు, చాలా విషయాలతో కనెక్ట్ అయి ఉంటుంది. అందులో మొట్టమొదటిది కేఎస్ పుట్టస్వామి జడ్జిమెంట్. వాట్ కేఎస్ పుట్టస్వామి జడ్జిమెంట్ సేస్? కేఎస్ పుట్టస్వామి జడ్జిమెంట్, I just remember the words of Justice D.V. Chandrachud. He is a justice at that time, now CJI. He says beautifully, the idea of liberty for all of us is not only from the external absence of restrictions, it even includes absence of internal restrictions. It is the persons who will have their liberty, and according to the Universal Human Rights Declaration, they used to have even privacy. So let us make that privacy. In his writings, he continued to say, and then we have Article 21, the vast judgment of Keshavananda Bharati stated Article 21 even includes right to privacy in case of some. See, one article, when I discussed to my constitutional students, this one article has several judgments. 121, for example, MC Mehta versus Union of India, right to environment. When people are debating about Delhi pollution, I said Subhash Kumar versus State of Bihar, right to pollution-free water, pollution-free air. When people say some people are not able to educate well, they are backward because of lack of schools, I said it is Mohini Jain versus State of Andhra Pradesh 1993, right to education. It's part of Article 21. And it included now case Puttaswamy versus Union of India stated you have privacy too. Interestingly, my dear friends, now things got U-turns, not single U-turn, triple U-turns. Because now some people got very interesting questions. What comes under privacy? What comes under privacy? There is a Nelsa versus Union of India judgment which says you have a right to decide about your gender. It is your privacy. Let us say it seems to be like a man, but I want to be woman. Let us say you can choose. It's your privacy. And this Nelsa versus Union of India made Indians to recognize the third gender, that is your transgender. See, I told you secondly, we accepted previously, but recently even Telangana High Court also struck down the Eunuch Act 1990 in Telangana. యాక్ట్ ఏం చెప్తుందంటే హిజ్రాలు ఒక చోట ఎక్కడన్నా సరే డ్యాన్స్ వేస్తూ కనిపించినా సరే వాళ్ళు అరెస్ట్ చేయొచ్చు. ఒక చోట ఎక్కడ రేప్ జరిగినా ఏదైనా ఒక ఇమ్మోరల్ ఇన్సిడెంట్ ముందు వాళ్ళని అనుమతిగా అరెస్ట్ చేయొచ్చు. ద యాక్ట్ ఇస్ స్ట్రక్ డౌన్. Till now, we started to treat them in a different manner. So finally, what is important, my dear friends, in this NASA judgment, Supreme Court accepted this third gender. Now, I told you there is one more U-turn. And that U-turn is going to now happen. That is one cinematographer, Navtesh Singh Johar, he went to Supreme Court and said, 377 is violating Constitution. It's a review petition, in fact. So Article 137 says you can file a review petition against Supreme Court once again. It allows. Finally, Supreme Court interpreted in manner that it says 377 is unconstitutional and allow people to have so-called same-sex relations. This is a beginning for next debate in the Supreme Court marriage rights. Why? We have Hindu Marriage Act. We have a marriage act for Christians, even Parsis, even Muslims too. Sharia, in fact, 1937. They all allows marriage as per their religious points of view, as per their cultures and traditions. Question personal, absolutely. But the question comes is where these people, these relations will be authorized or can be accepted by the government. So they started debates about marriage laws. And this LGBT community came in front and they started to debate. There is pride revolutions. They started in Bangalore, in Delhi, pride movements they started to do. ఈ సమయంలో వచ్చిన సంబంధం లేని జడ్జిమెంట్ చెప్తాను మీకు. అస్సలు ఈ విషయానికి సంబంధం లేని జడ్జిమెంట్ అదేంటంటే, హాదియా అనే ఒక పర్సన్, వాళ్ళ నాన్నగారి పేరు అశోక్ అని, ఇంట్లోంచి వెళ్ళిపోయింది అమ్మాయి ఇంట్లోంచి వెళ్ళిపోయే సమయం 16-17 వయసులో వెళ్ళిపోయింది. వెళ్ళిపోయిన అమ్మాయి కిడ్నాప్ చేసి పెట్టడం జరిగిందంత. బట్ ఆ అమ్మాయి కొంతకాలానికి బయటకు వచ్చింది, తన పేరు మార్చుకుంది, హాదియా అని చెప్పుకుంది. అంతకుముందు పేరు అలేఖ్య. ఈ అమ్మాయి ఏం చెప్పిందంటే, నా పెళ్లి నా ఇష్టం అని చెప్పింది. షీ వాజ్ మేజర్ అట్ దట్ టైం, కన్సిడర్డ్ బి. వాళ్ళ అశోక్ అని వాళ్ళ నాన్నగారు ఏమంటారంటే, ఆ అమ్మాయిని బ్రెయిన్ వాష్ చేసి ముస్లిమ్స్గా మార్చేశారు. అట్ దట్ టైం దట్ ఇస్ ద ఫస్ట్ కేస్ ట్విట్టర్ షేక్డ్ విత్ హ్యాష్ట్యాగ్ లవ్ జిహాదీ. Now Alekia became Hadia, but father said no. Father went to court. Where is my daughter? Father, unable to satisfy with the High Court judgment of Kerala, he went to Supreme Court. This case, very interesting to know. Very interesting, I will tell you. Case has moral and legal aspects. Our society says, the father has to do Kanyadan for his, satisfaction of his grahasthasrama. Opposite side, they are saying Article 14, Article 15. Why you are treating this girl, major girl? So when a major boy is doing marriage, you don't speak anything. Now, debate enter into 21. This time, the judgment, when I teach this judgment to students, I will be very careful. Why? Judgment says, right to marriage comes under 21 and personal liberty. Nobody should interfere. I told you the words of liberty, absence of restrictions, externally and internally. Right to marriage comes under Article 21. In this case, the case went to the next level within few months. Hadia judgment వచ్చిన కొన్ని నెలలకి ఇంకొక ఇంట్రెస్టింగ్ జడ్జ్మెంట్ జరుగుతుంది. శక్తి వాహిని అనే ఒక అమ్మాయి హర్యానాలో పెళ్లి చేసుకుంది. ఆ పెళ్లి కులాంతర వివాహం. ఆ పెళ్లిని లోకల్గా ఉన్న పంచాయతీ ఉంది, వాళ్ళు దాన్ని కాపు పంచాయతీ అంటారు. ఆ పెళ్లిని వాళ్ళు తిరస్కరించారు. అమ్మాయి సుప్రీం కోర్టు. ఈ జడ్జిమెంట్ ఇంకా పవర్ఫుల్ ఉంటుంది. నో ఎక్స్టర్నల్ పర్సన్స్ ఇంక్లూడింగ్ ఫ్యామిలీ, పేరెంట్స్ అండ్ సొసైటీ హ్యాస్ ఎ సే ఆన్ అడల్ట్ మ్యారేజెస్. Now two judgments saying one thing commonly: right to marriage is a personal liberty choice. With whom they are marrying, with whom they are going to have a life, is irrespective to you. Means society, parents also. Judgment says very extremist words. This doesn't debated among our community much, but this debated among LGBTs. What Supreme Court says? You can marry on your wish because it comes under 21. Now point is, we have personal liberty. Then these people started to marry. The first marriage in Telangana happened to Supriyo Chakrabarti, a hotel management professor in fact, which I met him once after marriage in fact. The words I spoke with Supriyo, today he is interested to call him as a Supriya. Okay, we should not laugh please, okay. Supriyo Chakrabarti says, marriage is my choice as per Supreme Court only. I am marrying. My own friend, he married a Punjabi person, Abhay Dhang. He says, I want to marry this fellow, I married it. I said, okay, but how can you get all the benefits? Because marriage is in India is essential for many things. Your partner will be a nominee for you. Let us say you are infertile, you can get a surrogacy last say you infertile marriage in 5 years. Nainitara faces situations here. Nainitara married, within few months he started to post images of twins. People got shocked. What is this? So, because Surrogacy Act says 5 years proved infertility. So, for surrogacy you need marriage. According to CARA, that is the Central Adoption Resource Authority, you need adoption, you need marriage. That too, the definition goes like this. That is, you should have what is called heterosexual couple should be there in CARA. These people got troubles. Insurance రాదు, హెల్త్ ఇన్సూరెన్స్ తీసుకోలేరు, లేదు లెట్ us say అడాప్షన్ రైట్స్ లేవు, సరోగసీ రాదు. This person, even not, the marriage is even not recognized. I told you with Samantha, the story of Dushyanta and Samantha. Marriage not recognized. Later he realized, oh, I married you. Then he came to know. Shakuntala, I guess so. Kalidas. I want to confirm here, what happened to Samantha should not happen to anyone. That is where they went to Supreme Court. This time they failed. They asked. I told you Hindu Marriage Act, Christian Marriage Act, and then passes. There is one more act. Special Marriage Act 1955. The act goes like this. Interfaith and interreligious couple, intercaste couple can marry. But you should have a process. The process is, you have to go to register, you have to apply so and so person. Then the process will start 30 days, they will wait for any objections, no objections they will go. But our today's generation, instant noodles, instant biryani generation, they don't take such stuff. 30 days is very used. So they will take one Venkata Babu photo and they will start Pelli Mantralu. If they love Muslims means they will start something, Christians their other music will go and they will marry. I mean, just kidding. Even I am seeing many things. So some special marriage act is there. Who will wait for 30 days, sir? They will kill us. So we will go for this option only. Instant students, we cannot do anything. So friends, I want to confirm. He went to Supreme Court and he asked one question. Recognize our marriage under Special Marriage Act. Interfaith, intercaste, but this is very unique one. Supreme Court established a 5 judges bench. You know, something is very important in constitutional interpretation. 5 judges are minimum, according to Article 145. 5 judges bench was constituted. The bench name itself, Supriyo Chakrabarti versus Union of India. 1 year, arguments went for 1 year almost. Not exactly days, but still. 2022 case filed. Hardly 2 months back judgments came. Judgments goes to 3:2 and says, we cannot recognize your marriage under Special Marriage Act. We don't, because we are not, I was shocked to see that interpretation in fact. Any interpretation beyond our limitation is going to violate special separation of powers. For the first time, even I shocked to see, Antamundu NJSC judgment vachinappudu, they entered into a separation of powers, they struck down without any concern. This time they say, no, we are concerned about special separation of powers, we don't want to enter them. And it asked the government to form a committee under cabinet secretary. This ends with one more thing, that is adoption rights. Court says, we are agreeing with you, but we are not able to support you because the 2 judges are minority. Interestingly, CJ even minority at that time. So, in the short span of 10 minutes, I just explained you the pain and traveling story of LGBT community. Okay, whether you accept or not, many sociologist documents are writing pros and cons. Even Indian society is saying it is only limited to only urban areas, not to village areas. But still, one thing is important. It is the constitution which we framed in 26 January 1915, enforced in 1950. Constitution gives us one important thing, that is liberty. Preamble says liberty of thought, liberty of expression, liberty of belief, liberty of worship. Why can't we accept them as a part of liberty of thought and expression? Accepting may create some kind of challenge to the society, but it is not going to create any kind of disorder and public order. These are not my words, words given by even Honorable Supreme Court itself. So I want to conclude by saying one thing. There is one judgment, that is Genova witness case. One of my favorite judge, Chinnappa Reddy, write these lines. Our history teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Thank you so much.